Nasciturus fiction is a legal principle that allows an unborn child to be considered a legal entity and inherit rights, even though they are not legally considered a subject at the time of conception. This principle is used to protect the rights of unborn children. The nasciturus is regarded as having been born at the time of his conception whenever it is to his advantage. It operates as follows. If it appears that a nasciturus would have had a certain claim or right had he been born, the legal position is kept abeyance until he is born and acquires legal personality, or until it is certain that he will not become a legal subject. These are the requirements for the Nasciturus fiction. 1. The nasciturus must have been conceived at the time the benefit accrued to him. 2. The nasciturus must subsequently be born alive. If not born alive, the nasciturus is considered as never having been conceived. The capacity of a nasciturus to inherit is explained by the case of ex parte bodel Steenkamp. In this case, the testator left the residue of his estate to his daughter, and to the first generation wat by datum van dood, in die leeuwen is. The testator's daughter was pregnant at the time of his death, and subsequently gave birth to Paul Johannes. The executor to the estate sought a declaratory order on the issue of whether only the children born at the time of the testator's death would inherit, or if Paul Johannes, born after the death of the testator, would also be able to inherit. Curator ad litem for the two children already born held that the words, "who is alive at the date of death," is sufficient enough and without ambiguity to exclude the unborn child from the estate. 1. Sufficient and without ambiguity. 2. Exclude the unborn child from the estate. Curator ad litem for Paul Johannes was of the opposite opinion, stating that there is no evidence that the testator wished to exclude the unborn child from his will. The legal questions are: 1. Does the nasciturus have the legal capacity to inherit? 2. Is Paul Johannes entitled to a share of the estate? Judge de Villiers R. held that the nasciturus should be able to inherit by means of the Nasciturus fiction, subject to being born alive and it being to the advantage of the nasciturus. He further held that Paul Johannes is entitled to share in the estate of the testator in equal amounts to his mother, brother and sister. Judge de Villiers R. referred to the decision of House of Lords in Elliot Vertum Lord Joyce, where the court held that if the testator's intentions are not clear, when words as "in life" or "born" are used in conjunction with a specific timeline, and there is no other specific statement specifically excluding the unborn child, it should be presumed that the testator had no intention of excluding the unborn child from his will. Follow us for more case summaries.